When the laws for wills and trusts were developed, digital assets weren't a thing. So they have to be considered. Generally, they're dealt with in a will, but most people forget all about them. So let's talk about digital assets for a moment. If someone wants loved ones to gain access to files that are password protected, I mean, if they're not password protected, then somebody can get access to them. But you have to make, if they are password protected, you have to make them available, the passwords accessible to someone afterwards. So things to think about is, well, what assets do you have digitally? A lot of people have photos, right? We have social media accounts. I keep a Dropbox in a cloud. Nobody's going to get access to those unless I tell somebody that I have those things, right? Email accounts, videos, any personal storage files, access to PayPal. Maybe you use PayPal or Venmo. So those things have to be considered and accounted for. So how do we do that? Well, if you're using social media, let's start there. You're gonna have, for your personal computer, you're gonna have to leave access to passwords and such, so people can access the videos that you have, on your actual hardware. But let's talk about social media and accessing accounts and maybe internet service providers who have your email on. You have to review the policies. Each one of these have custodian policies, right? Some of the more popular ones, Google has an interactive account management system. You can actually tell Google what to do if basically your account becomes inactive. It can be deleted. You can provide a person who gets access, and then that person contacts Google. It's kind of like having a level of power of attorney. If you want someone to have access to your bank accounts, they can't just walk in and say, hey, I got to have access to the bank accounts. There has to be some sort of formality or designation by the person. Facebook has you can delete it or create a legacy account. You get to choose. You can go in and choose that. Instagram will memorialize the account, but doesn't allow people to make any changes to it. Twitter will just deactivate upon notice of death. LinkedIn also removes the account upon death, but you can designate. So my whole point is you can designate a custodian for this purpose in your will, and that should be sufficient for these entities, ISPs or social media accounts or any account to access. Amazon, for instance, okay? So it's something that your clients or you should consider when setting up estate planning. So a testator now has a will. The question is, can it be changed or revoked? Absolutely. Testator can generally revoke or alter a will at any time prior to death. They have to have capacity, but they can do so at any time. If they revoke their will, chances are they're making another will versus wanting to die intestate, right? And usually the new will specifically state that this will revoke any previously made will, but it has to follow the formalities rule. Making amendments, a testator can amend the will. We say that they create an addendum. Some folks call it addendum. We call it a codicil. Executing a codicil. This allows a testator to change specific terms in the will, but keeping the others kind of in place and the rest of the will intact. But that codicil must meet all of the requirements of a will. So let's take this example. We have Uncle Tom, who has a long and elaborated will, but now he wants to leave his sterling silver Swiss Army knife to his cousin Larry. Rather than redo the entire will, Uncle Tom just executes a codicil for that item, piece of personal property. A codicil, this could also be used to supplement a will too, to handle any sort of after acquired property. You have your will, but you're still going to acquire material goods that you might want to leave to a specific individual. We can use a codicil for that. Otherwise, that stuff is going to fall under the residuary could potentially fall there. All the rest of the stuff not accounted for, right, goes to the person who has the residuary. Anyhow, codicil, it's an amendment, has to follow all of the requirements of formalities of a will. Revocation of a will, can revoke a will at any time. Could be as simple as destroying the document, throwing it in the fire pit, ripping it up. You can put an X through all the pages. You can write revoked across it, or like I said, by executing a new will. Some states, including New York, recognize a partial revocation. This is done by crossing out provisions of a will. You might just go, maybe you don't have that piece of property anymore, so you just got to go in. You go in and you cross it out. If you don't cross out a provision regarding a piece of property that you no longer have, it just doesn't get distributed. So what will happen is those provisions that are crossed out, they just won't be recognized, but the other ones will. However, you cannot cross out a provision and then add stuff. You can't say, I'm crossing this out, but I'm going to add this component to it. You can't do that. That has to be done in a codicil with the proper formalities. It just won't be, if you do that, it just won't be recognized. Revocation by marriage or revocation by divorce. A testator who marries after making a will that does not include the new spouse. The new spouse receives the amount that would have been taken had the testator died without a will or intestate. And then the rest of the estate will be distributed according to the terms of the will. This kind of reverts back to potentially how New York handles a disinterested spouse. You can't disinterest your spouse. So even though you've gotten married after the will, the new spouse is going to be accounted for purposes of inheriting. Revocation by divorce. A divorce or an annulment cancels the ex-spouse's inheritance rights under the will. So let's say you had a will that you made with your former spouse and you never changed the will, and you pass away. The ex-spouse isn't going to inherit per the will. But that doesn't mean the new spouse stands in the place of what the ex-spouse would have got. The new spouse is going to still receive per the intestate laws of the specific state. And revocation by children. If a child is born after a will was created, most states allow a child to receive some portion of the estate if there's no provision made for that child, unless it appears that the testator intended to leave nothing to the child. So we can have revocation by children as well. So next up, we're going to talk about when a person dies without a will. Well, without a will, we'll see how the property gets distributed.